distinguished guests, eminent guests, and all the audience in this room today. I'm Aparajita Bhatt, and I'm your moderator for this session, which is organized and curated by National Law University, Delhi, under the India AI Impact Summit 2026. And the topic of today's session is Harnessing AI for Improving Judicial System in India. And I'm really happy, very delighted to introduce the distinguished panel for the session today. We have with us Honorable Justice Dinesh Maheshwari ji, Chairman Law Commission of India, Shri Rajneesh Kumar ji, COO NEGD, Ms. Arya Tripathi, Partner Cyril Amarchand Mangaldas, Mr. Vikas Mahendra, CEO Terrace, and Shri Shardul Shroff is soon going to join us. He is the founder and executive chairman of Shardul Amarchand Mangaldas. He has reached here and will be able to join us in another 2 minutes. I now request Professor G.S. Bajpai, Vice Chancellor, NLU Delhi, to give his welcome remarks.
Very good morning to all the distinguished panelists, esteemed guests, and dear students, and all ladies and gentlemen who are present here to this very important panel discussion on harnessing AI transformation, harnessing AI to transform India's judicial ecosystem, convened under India AI Impact Summit 2026 and being organized by Judicial. In my I only have to say that the Indian judiciary is the largest justice delivery system in the world, and judiciary carries the dual responsibility of preserving constitutional values while responding to the growing demands of adapting and imbibing constitutional values while responding to the growing demands of the society. Increasing case complexities, rising dependency, and expanding access to justice expectations require innovative yet very principled solutions. In this context, artificial intelligence presents both an opportunity and a challenge. India currently stands at a very defining moment in its technological journey. As artificial intelligence reshapes governance, commerce, and societies, its integration into judicial system presents both opportunity and a very profound responsibility. AI can support judiciary through predictive analysis, smart case management, automated legal research, drafting, translation, and transcription, as well as data dashboards and performance monitoring. If deployed thoughtfully, it can reduce dependency, enhance transparency, and make justice more accessible. The question before us is not whether AI can assist the judiciary, but how it can do while preserving process, judicial independence, fairness, and the constitutional values. We are honored and delighted to have with us a very exceptional panel of thought leaders who bring judicial wisdom, policy insights, technological experience, and practical experience to this conversation. We are privileged to have with us Honorable Mr. Justice Dinesh Maheshwari ji, Chairperson of the Law Commission of India, Shri Shardul Shroff, Shri Rajneesh Kumar ji, and Mr. Vikas Mahendra, as well as Ms. Arya Tripathi. And this distinguished panel will identify the challenges of AI in judicial ecosystem, regulatory safeguards, best practices, and collaborative frameworks necessary to harness. AI responsibility in strengthening India's justice system continues to be very important, and I'm sure the insights emanating from this panel will help us examine both the promise and the prudence required in this direction. I look forward to a very rich and thoughtful discussion today. As we commence this session, let us remember the goal is not automated justice, but augmented justice where human wisdom empowered the technological precision. With this, I once again warmly welcome to all of you to this panel discussion. Thank you one and all. Have a good day.
Thank you, Professor Bajpai. And we've already set the tone for this session that it's not the artificial intelligence but assisting the judicial system, which is the main objective behind discussing and deliberating today. Coming to the topic of the session, which is harnessing AI for improving Indian judicial system. As we've already said, sir, India is one of the largest judiciary in the world. However, currently it's navigating through different kinds of pressures, including backlogs and procedural delays. There are concerns related to access to justice, and so many other issues are there. On the other hand, it is believed that AI has the potential to revolutionize this judicial system of ours by enhancing efficiency, transparency, ensuring better access to justice. It can do a lot of things. It can do miracles in terms of better case management, judicial automation, so on and so forth. So this panel discussion wants to examine the transformative potential of AI with respect to Indian judicial system. And on this note, I would first like to know from Justice Maheshwari ji, sir, you have been the custodian and guardian of constitutional values all through your life. If you can share your insight on as to how can the adoption of AI in the judiciary be aligned with constitutional values such as fairness, equality, access to justice. Your thoughts on this, sir?
Thank you, ma'am. Yeah, a very good morning to all. Professor Vajpayee, other panelists, ladies, gentlemen. It's indeed a profound moment for all of us. And India is hosting a summit of this volume, this nature, and where we are all going to discuss about, ponder over the use of artificial intelligence, as is rightly indicated, vis-a-vis, I put it this way, our authentic intelligence, which is always a part of us, and integrating both of them. Before coming to the constitutional values, let me first underscore some of the fundamentals of the Indian values and the Indian framework. The hallmark of India is diversity. But then, the stamp of India, the signature stamp of India is unity in diversity. Now, this is how India as civilization is known to the whole world. We have the capability, we have always been doing that. Well, accepting any stream of knowledge, integrating it with our own values, our own systems, customizing it for our purposes, and then proceeding ahead. The examples like, well, the basic principles of Ayurveda, well, we'll integrate them with the modern medical advancements, and we have a holistic healthcare system. Well, a little different. Even the culinary systems or principles or experiences coming from all over the globe, we'll take them and we'll customize them for our purposes, leading to, as we all know, fusion foods. Like we as Indians will prefer fusion foods rather than the frozen foods. The idea is, the fundamental is, that we have always been a civilization known for universal toleration, and we have permitted. We have never rejected anything, but we have also never proceeded in contradiction to or anything of versus anything else. And here in this summit also, it's our discussion, our thought processes are not going to be of human versus machine, but our thought processes, and particularly when we'll be talking about the judicial system, would be integrating both of them and making the best use of the technological advancements, whatever they are available, and more particularly in relation to the artificial intelligence. Now, artificial intelligence, friends, integration of that into the Indian justice delivery system represents definitely a transformative movement. It is rightly put by Professor Vajpayee. It's offering vast opportunities, but yes, some of the critical challenges. When we are capable of integrating anything, customizing it for our purposes, I'm very sure we as a collective, we are going to make it sure that artificial intelligence also, one of the rapidly growing advancements of the present day world, is also going to help us, is going to be our assistance, is going to be our an associate, another tool or another mechanism to help us grow. Artificial intelligence, as we all know, is already in use, in vogue. It's being actively used for drafting contracts, scrutinizing evidences, translating judgments. The Honorable Supreme Court has come out with two very significant initiatives on that. One of relating to judicial research, another relating to the breaking of language barriers and providing translations. But that is just the beginning, friends. I'm very sure we are going to put artificial intelligence to much better uses in the days to come. But yes, the requirement for us, particularly the persons concerned with law and justice delivery, is to make sure that wherever intelligence is required, and more than intelligence, where consciousness is required, as Yuval Harari way back, about 10 years back in Homo Deus would indicate, it is going to be, the advancements are going to be decoupling of intelligence from consciousness. Now, this consciousness is in the soul of Indian thought. It has always remained like that. When we talk about our constitution, we find justice, liberty and equality are the promises of our preamble, coming in that order. Justice reigns supreme. Justice comes first. Everything follows. So that is the commitment of India. Our civilizational values, our constitutional framework, all of them give us the fundamentals of constitutional morality. Now, constitutional morality, as we all, as the students of law know, it is going beyond, looking beyond, and at the fundamentals of all the constitutional values, living not by text, but by the texture of what is meant to be said. Now, the capability of discerning the texture of anything that is unique to the human beings, that is unique to the legal brains particularly. And there, the requirement would always be is that we keep our authentic intelligence always at the forefront while utilizing artificial intelligence for whatever purposes. It's not the time here to discuss about the fallouts of or the shortcomings of the indiscriminate use of artificial intelligence, or rather unintelligent use of artificial intelligence. Like we are aware of the examples where citations were presented to the honorable courts, which were found to be non-existent at all, starting from some foreign jurisdiction that percolated down in India also. But these are the examples. They do not bother us. What is needed is for all of us to learn from those kind of examples that the machine is capable of, the machine is tuned to, and the algorithms are meant for, well, storing everything. Well, whatever goes in is retained there. It's different than the human mind who is able to differentiate between right and wrong, correct or incorrect, relevant or irrelevant. So the fault line with any over enthusiastic Gen Z person who is simply relied on the artificial intelligence output and presented certain so-called citations to his senior. It was the embarrassment of the senior presenting that in the court, finding that none of them existed at all. But then the machine is, the problem with the machine is the difficulty in unlearning. But we as human beings are capable of unlearning, and that is where we do differentiate. So friends, when we are going to discuss today this panel, and we have brilliant legal brains with us, so I will be handing it over to them. We discuss about, we'll come back on to certain aspects of constitutional morality and how do we integrate them for our purposes. Thank you very much.
Thank you, sir. So we started on a very positive note that probably we are through technology ready to adopt and adapt to this technology and ensure that it becomes a part of the judicial system, provided there is no unintelligent use of artificial intelligence. That's a very correct thing you mentioned, sir. Moving on to Arya. So, although we are ready to adopt this technology, Arya, but there are going to be many practical implementation issues and concerns, especially structural concerns are there with respect to transparency, accountability, preventing algorithmic biases. So my question to you is that what are those key challenges in implementing AI-based tools within the judicial system? And a follow-up question that how can algorithmic bias arise in judicial AI application, and what safeguards are necessary to detect them?
Thank you, Aparajita. At the outset, thank you for making it today. I'm very happy to see everybody hybrid pretty early by Indian standards. But just to straight off dive, I think I will be using two terms very frequently. One is JDM, which is judicial decision making, and the other one is ADM, which is automated decision making. So bear with me when I am running past and whizzing and using the terms JDM and ADM. First and foremost, in any sort of ADM process, which is automated decision making, how does automated decision making work is that there is a component of artificial intelligence, there's a component of machine learning, there's a component of natural language processing capabilities, commonly known as large language models. So all of these combined over a stack of artificial neural networks collaboratively enables a system where a machine is in a position basis three things to be delivering automated decisions without human intervention. What are these three things? First is intelligent perception. Very basic, what we are currently using in our B2C context, intelligent perception. We have large volumes of data in natural language which is being processed, and then the machine interacts basis that information with you. Your normal prompt and outputs and input cycle. The second phase is called as intelligent cognition, where it gets a little more tricky. Where there is something called as a feedback loop, where there is something called as a self-learning, which means that even if your training data was limited to a certain bucket, in intelligent cognition, the machine is in a position to learn and adapt basis what is already being provided. And the last is where we call as intelligent decision making, which is automated decision making. Now, across the globe, various jurisdictions have been debating on whether ADM can qualify as JDM. It is very encouraging, as you rightly mentioned, sir, that the Supreme Court has initiated initiatives which helps in legal research and translation, overcoming language barriers. Similarly, Estonia, as another country, has adopted AI #1 for speech transcripting, which means that when a court proceeding is happening, the AI transcribes it, and then it anonymizes it in sensitive trials to preserve actually privacy. a variety, a bunch of cases exist. In fact, we don't have to look very far. If you look at China, they have something called as Project 206. Project 206 does a bunch of judicial support activities starting from case management to evidence collation, where it identifies what relevant facts are, irrelevant facts are, what evidence is correct, what evidence may not be appropriate. All of that is being done by Project 206. Going to US, and this is a little unpopular, perhaps people may have heard about what was happening with Compass. Compass was an AI-enabled tool which predicted offenses and was significantly influenced by racial biases. And this was questioned in two court judgments. One was in Wisconsin, where the typical problem of, I will come to these problems, a black box problem was highlighted. And the court held that the black box problem is not a real problem when it comes to ADM being JDM. But at the same time, the Kansas court on the same software gave a completely different judgment, saying that this is not in alignment with rule of law. So first, the three concepts: intelligent perception, cognition, and decision making, followed by a very wide array of adoption of ADM into JDM processes. Now, Aparajita, as you rightly mentioned, what are the problem statements? Bias. Bias and heuristic stands out as one of the most singularly significant problems. Why is that so? Bias is basically a translation of human bias. So if you see, go back to 2017 when India did not have a right to privacy. If we were to use JDM to decide whether Indians deserve a right to privacy, I don't think we will all be discussing about privacy anymore. Why so? Because all the past judgments before 2017 did not singularly recognize informational privacy and privacy as a fundamental right. They were always attached with certain factual context. So if an ADM were to be sitting there and deciding and not our honorable justices, I feel we would have landed at the same sort of an outcome where there would not have been a uniform resounding judgment saying that there's a right to privacy. Why? Because it would have been trained on data sets that would have exhibited the heuristics of judges as it exists. So that is number one. Judges suffer from a variety of biases when they adopt artificial intelligence tools. For example, commonly considered as hindsight bias, which is very prevalent in the US. So in low-risk matters where there's a jury trial happening, if you're using an AI tool, it could suffer from hindsight bias as to how racial discrimination has worked, so on and so forth. And you might end up saying that, okay, that neighborhood is largely populated by a certain kind of color, and therefore the rate of crime is significantly higher. So this is one of the illustrations of what we call as hindsight bias. There is also recency bias. So frequent times, a number of times if a particular incident has occurred, then the AI starts believing it as a fact. It will not go down to verify whether it is a fact or not. So these are significant biases that can impair how judicial decision making works. The second piece is black box problem. What is black box problem? Even technical experts grapple through this. Black box is the undefinability. You can't really explain how machine learning is working. And this is because of the various layers of neural networks within which the data is getting translated. So as a result of which there's a significant degree of opacity, which translates into lack of transparency. So applying an AI tool for JDM might significantly suffer from black box, as happened in the case of Compass, where the petitioner actually stated that I need to know what is the algorithmic logic that has been used by this particular tool. And the court was unable to explain. Apart from that, there are various problems.
So we'll come back to you
sure,
for
absolutely,
your concluding remarks on this.
Yes.
Well, we'll have to pause a bit here for a very important mandate of group photograph, because that's how we were supposed to begin with. So for 2 minutes quickly, if you can come forward, I would request all our distinguished panelists for a group photograph to come forward, and then we can continue with the discussion.
And I promise I'll only take 2 minutes after that, because then everything falls into its place.
Yes, so we can continue with the session now. We have started with the question of constitutional morality, constitutional values, and how do we align them with AI. We have also looked at some of the challenges, implementation challenges. Now I would like to move on to Shardul sir. I have a very important question here that while we've been discussing about integrating AI into the judicial system, there's another important question here, which is that it's all about reducing the burdens on the court. And can AI help resolve disputes outside the traditional adjudication system remains to be a very, very important point to be deliberated upon. So on this, I would like to ask you, how can AI tools enhance efficiency, predictability, cost effectiveness when it comes to other dispute resolution mechanisms? And what are your insights from a practitioner's perspective? What challenges do law firms face with respect to dispute resolution structures by incorporating AI?
Thank you, Audra. I think in terms of the speed of decision making, the ability to collect data, to sift data, the issues in relation to bias questions, the issues in relation to the question of approaching the particular matters in a way in which you have to resolve. All these matters are tackled matters in the sense that these are not open-ended as continuing issues. They have been addressed. The aspect in relation to what is not resolved is the black box question as was just mentioned. The other questions effectively are the non-delegation of decision-making processes to any AI tools. The question of whether the judgment is really delivered by the mechanical means, or is there a human being at the end of the process, and it is the human being which has rendered the decision. If the decision is passed over to the machine, it would be bad law because no one has delegated that power to the machine. Even in selection of an arbitrator or selection of a mediator, the decision is such that the party has delegated. The decision is that has the delegation of authority been made to the person individually and has not been made to the machine. So this is a typical characteristic or differentiation between the process as it is. In fact, it could be a ground for setting aside an arbitral award under the New York Convention. The disclosure, the transparency, party content, the supervision of the AI generated, and the non-delegation of decision-making process are keys as far as the process of resolution is concerned. When you take the law firms ultimately, there are multiple purposes effectively get resolved. The aspect of segregation of evidence, the aspect in relation to collection, the aspect of dealing with the evidence, the question of preparing a list of dates, the question of a due diligence which is conducted on the data available, are all matters which are procedural matters where the machines have resolved the question of speed. So there is a clear crunch to the time that is taken, but you have to be careful that you do not get into the problem of bias or hallucination. There is a machine-related hallucination which typically happens when you spread your data and you allow external inputs into the data, because the machine scrapes the data from the access to which it is amenable to. So the question is therefore, do you get wrong parties, do you get wrong judgments into the process of decision making? This is a common complaint in relation to processes where the machine has been let loose in the manner in which it is decided. So there are several judgments even of our courts where this question has arisen. Parties who are not parties to the original proceedings found themselves into the array of parties. the question of whether there were false judgments, in the sense that the name was familiar, but the contents of the decision were just not correct, and they had sort of manipulated the judgments. In fact, lawyers were found to be resorting to this particular technique, and therefore the human supervision over AI has to be ensured. It's not a hands-free kind of situation. In two cases, in the Gammon versus Chennai Metro Rail Corporation, the Chennai High Court actually developed a procedure whereby engineers worked with the court, and they prepared 4 principles. The system must be confined to the record, so no access to external stuff. It must not invent, infer, or give legal opinions. Only present, re-express, retrieved experts. Outputs must be traceable and viewable against the record, and all interactions, whether procedural or substantive, must be logged and must be available for transparency. The question of transparency was also discussed in the sense that if you put in more data, if parties are accessing stuff which is not in the case, an external material is resorted to, you have to advise the other side. And these are matters which are decided when you really set down the principles which will be applied in the case or in the mediation before you actually prepare your material. So the agreement between parties and the expanse that you really are going to cover is a matter of agreement, especially when you have resorted to AI. So in the case of Deepak versus Heart and Soul Entertainment Limited, the question of fake generated cases came up, and the court came down very heavily. In US, for example, there are sanctions against a lawyer where he does not supervise adequately, and the case is led to be open-ended, and the resource question has to be looked at. In the problem of KMG Wires Private Limited versus National Assessment Center, the government was accused of fixing the process in a manner where it results in a particular outcome, and that was punished for the reason that the outcomes were prefixed, and therefore there was no freedom in decision making. And the process effectively therefore proceeds on that particular.
Thank you so much, sir, for your insights. And all of us in the room here would agree that we need to shed our hesitation in AI when it comes to adopting this technology. But while saying so, it's also important that there has to be a responsible adoption of AI, right? It means calibrated deployment. And coming to that, we need to learn more about how to exactly implement and deploy AI. So we need to learn about use cases. And I think Rajneesh would be the best person to inform us and give his inputs on the use cases in judiciary while it comes to adopting AI in a responsible manner. Over to you.
Thank you, ma'am. And while I was listening to the insights, as Maheshwari sir said, that this is not human versus machine, and Professor Vajpayee said, it's not automated, but augmented. And I'm from National Governance Division. We do a lot of IT projects for the government. We've been through a lot of challenges in our own work also. And I will touch upon one aspect of judiciary and judges, sir. The judges are not confident that whenever they use a tool, is it going to USA, is it going to Russia, is it going to China, where are the servers located? So we found a very interesting solution that for all judicial cases, say last 50 years, you want to put it in a server. There's a little device called a NAS, Network Attached Storage. You put it in the judge's chamber. You have it connected with say a MacBook Pro or a Mac Mini or just inference server. And then you have a data diode, which means that it will only let you access data, let nothing else come to the data. So one of the great challenges that any judge would face is, what about my drafts? So there has to be a complete data erasure mechanism. When the judge removes the machine from its place, the machine should have absolutely no trace of what was done by the judge. All this is possible, and it's a sub 10 lakh solution. The only challenge that here comes is, as Madam had said, how do we build a good tool which can assist the judge? So it's not human versus machine, but one thing that can come is that there are mechanisms for guardrails. That is, the problem with LLM is it never stops. It will never tell you, I don't know. It will keep answering. So that is the thing that lawyers, technologists, LLM experts have to come back and sit and say, you stop here and say, this is all I know. Last 50-year judgments I have checked. This is the reference, and the legal assistant or to the judge or to the adjudicator can always ask the assistant, what is the reference? Have you cross-checked it? And the cross-checking also can be done by the AI. So in a sense, if you look at the technology of LLMs, it is a adversarial network, wherein one part of the network is doing something, other part is countering it. So it's a self-criticism mechanism, wherein you get the last solution as somewhat correct. So one thing more that we realized with the legal aspect of using AI is hallucination, which is looks so accurate that even the greatest experts will fall prey to it. As just sir gave an example, that some case was concocted by some other references to the other places. Now for that, we can have another AI system in the mechanism itself, which keeps that counter ready. So all I can say, ma'am, is, and sirs, that if the technologist and the legal experts come together and we build a sovereign LLM, which a lot of companies in the country are doing, it can be a ray of real assistance to the close to 650 district courts, 25 high courts, and when we interact with a lot of adjudicators, not just the judges, the NCLT, the NCLTs, income tax separate tribunals. In those cases, it is not so difficult also, because most of the arguments or cases are, very fact-based, unlike a civil or a corporate case. So, my suggestion to the panel is, let's start with the adjudicators, the tribunals. We have a learning, and then that can very easily come to civil and corporate cases. Our criminal cases, I'm not very sure because we haven't studied that aspect. But as far as civil and corporate cases are concerned, there's a real case of a simple machine being the adjudicator, connected to a network attached storage, and that network attached storage is a very interesting thing. Anywhere in the world, you can access it through a virtual private network, and you are safe, and no one else can access it. In fact, we can also prove all connections withdrawn, no Wi-Fi, no Bluetooth, no LAN connection, and still the machine will work and give you a good judgment or a draft. That's all I can say. Thank you.
Thank you. That was some real finding here. To all the audience here, I think you would agree with me. We've got some very, very important key takeaways from the three important conversations which we've already had. Moving on to Vikas, you have been very active in judicial automation tools and also towards dispute resolution. The question still is AI-driven automation. How would that improve judicial efficiency, case automation? So can we have quick inputs from you as well?
Thank you very much. Let me start with what we are already doing. Let me tell you what is it that we are piloting right now and therefore is likely to be in place in a couple of months, and what is the future going to look like. We already, as some people might know, we are using transcription to transcribe Supreme Court proceedings in constitutional bench hearings. We're doing that not just in India, but in the Dubai International Financial Courts, the Abu Dhabi Courts, the Singapore Supreme Court. So I wanted to give that background to say, what we're building in India is not just for the Indian courts. Obviously, the Indian courts is one of the biggest consumers that we want to address. The need is much there. But I think it's also about taking that step forward to say, what is it that we can build, where we're not copying or adopting what other countries have done, but really setting the standards to do what is possible. For instance, in the ADGM courts, one of the things that we're doing is live translation of court hearings, where in special economic zones, where the language of proceedings is English, but the parties are not English speaking, parties often struggle to follow what's being said in court. What we have offered is a solution to convert that into Arabic in real time with a significantly greater accuracy than even a human translator doing it in simultaneous interpretation. Those are the kind of things that I think we need to start looking at. But I think there's more than that. Today I can tell you that there are 3 live pilots that we're doing where a lot of what the theoretical discussions we're doing has already been put into action. We are looking at building systems that are tuned specifically for judges to use AI responsibly. AI that does not tell them what the decision is, but gives them everything else that they need to do to make that decision much faster. It's everything that lawyers have already been using. I think Sir already talked about, for instance, the list of things, the factual chronologies, but we go beyond. We look at how we can analyze cases in a manner that you surface the positions of the parties, the points of agreement between the parties, the points of disagreement between the parties, the key legal principles, and where the key legal principles are there, we are working directly with the judges to identify the key 50, 100, 200 cases per roster. Because obviously you might have 17 million cases in India, but all of us know as lawyers that you don't need all of them to decide every case. There are some key principles in each roster. We're working with the judges to identify them and surface them literally as the pleadings come in. Where the way we see it, the judges look at cases in three stages. The day before the hearing, when the list comes out, where you have about 70 or 80 matters that you need to understand. So you have about 30 seconds to a minute to read each case. 5 seconds between when the lawyer is walking from his seat to the podium to argue a case. You have 5 seconds to literally try and understand what the case is. And then you probably have about half an hour or an hour to decide the case and draft the judgment. So we're building tools which has all of the guardrails that are here to address each of those three elements and tell the judge what they need at each of those points. At none of those points are we telling them what to decide. All we're doing is distilling the position of the parties. And our aim is, as we go forward, that distillized position is actually given back to the parties. So when you're talking about transparency, when you're talking about no hallucinations, when you're not talking about AI's limitations, what better way is there than to put it back to the lawyers to say, hey, listen, this is what the AI has said. I will of course apply my mind, but if you feel that there are gaps, if you feel that there are issues that this hasn't picked up or it's characterized it wrongly, it's your chance to then give your input on it. So imagine a hearing that is happening after all of this synthesis. So instead of the lawyers starting with saying, this is the fact, this is when X was born, Y was... You start with saying, the judges already know what the agreed positions of fact are, so let me get straight to the disputed positions and economize on the time required for hearing. Add to that the transcription that you're already doing. So you're not just synthesizing digital data that is your electronic filing, you're not just synthesizing the evidence that is already on record, that with our RAG system, which are fine-tuned for the judicial models, are retrieving only the most relevant ones in a more limited data set, but you're adding to that a hearing where all of these positions get crystallized, and therefore when the judge sits down for that half an hour or 45 minutes, they really have not a static document. They don't look at a petition and then say, okay, this is what the position was 10 years ago when the matter was argued, but literally how the position has evolved from that day over maybe, hopefully not 10 years, but until the time that judgment is delivered, what is the evolution of the parties, where are the points of agreement, so that immediately you are able to distill out and generate a decision, which is your decision, which is a human decision, but augmented with technology. So I think a lot of these are novel. These are not being done in the rest of the world. When you're looking at automated decision making, you're jumping the gun. You're going from saying, I'm going to give you all the data, you generate an output and give it to me. We're saying, don't do that. Let's keep the human in the room, but ensure that you use all of the benefits of technology to aid the decision maker. And that's literally what we're doing today with arbitrators, with judges, and with arbitral institutions, all of whom are looking at making some very critical decisions on very high volume data without the use of technology, because today technology is it's inaccessible. For all the reasons they said, sovereignty reasons, black box reasons, there are also elements about where is the data getting stored, where is the data getting processed. So when you build systems with the judge, with the arbitrator, the institution at the very heart of the solution, you will automatically program for it. And when you have these guardrails embedded, it also makes it easier for parties to accept. So when we build tools for arbitrators, and the arbitrators tell them, listen, I'm going to use Microsoft 365. They're like, okay, will the arbitrator ask Microsoft 365 to tell them what to decide? Because Microsoft 365 will give you an answer. But on the other hand, if they use a tool that we've curated for them, which will tell you that I cannot give you that answer, it is beyond the scope of what is the permissible use of my platform, parties are more likely to consent to the use of that kind of technology. So it is really that which we started off with, saying, look at the key decision maker, because they are the ones who are scarcest, who are the ones who need to do the most. How can we help augment their capabilities? And also think about this from the context of judicial training. We are working with the brightest judges across the country and Supreme Court to distill out how they think a case needs to be analyzed. And we are building systems with that knowledge and logic And that is being used by the district court judges in the hinterlands of India. So they now suddenly are applying frameworks that have been designed by the best of experts in the country to do their work for them in the language of their choice. That I think is the true power, and that's why we're looking at, when you're looking at the theoretical concept, we need to look beyond that to say, how can India contribute not just to taking what's happening elsewhere, but really
Vikas,
to
I have to
contribute to
interrupt here. I'm so sorry. Thank you so much. That was quite insightful, and you actually made us imagine the entire courtroom exercise, which will be a AI-enabled courtroom. So thank you so much for that vision. Now, as we are moving towards concluding the session, I would like to again come back to Shardul sir. So what are your insights on the deployment of AI? Should it be restricted to decision support or assisting the decision making, or the real decision making which is done with the help of AI? And where should that line be drawn? So if we can have insights from you.
As I mentioned in my opening statements, one of the question of bias and the question of fair decision is this precise question as to whether the judge-made decision has to be really automated, or is that something which can be only restricted to the human being behind the process. In USA,
so we can go in some other room.
In USA,
We can go in any room.
In USA, they have actually, and several of the tribunals which have really made their rules. One of the principles that they have embodied in relation to the decision is that they have delegated that authority to the natural person and not to a machine. So if they find that the line has been crossed, and it is not just the procedural element, but the judicial element which has been decided, it would be a bad decision, because it is not in accordance with the entrustment of the matter, which was based on who is the judge and how the processes are effectively evolved. So that's the solution which has been found, and that's what is likely to happen in relation to future matters.
Right, sir. Thank you so much. And now I would request Justice Maheshwari ji, if you can give your concluding remarks. We'll start from the same question here on for concluding remarks also. How to integrate AI into the judicial system while ensuring constitutional values at the same time?
Yeah, thank you so very much. It was a wonderful insight from all my panelists over here, and these are the things we keep on learning. As we learned today also, that we have the capacity as human beings to learn as also to unlearn. The capacity we have to develop about the AI or any machine tool also, when we have to inject that capability to unlearn, or at least to block what should not be learned by that, or what should not be used by that. It has been rightly indicated that if there is a propensity to generate fake, not only deep fake in the sense of the images, but even the citations or the diseases, that AI would be countered by another AI, blocking, anything of fake creation. So the possibilities are abound, and possibilities are plenty. We keep on proceeding, but one of the common factors which we were discussing here had been about the actual decision-making process, because all said and done, in the end of the day, it's if we talk of the court, the justice delivery system, it is ultimately delivering of the justice. As judges, as we know, we are trained about, that there is always a difference between disposal of a matter and delivering of a justice in a cause. And the effort of the lawyers, the judges, the whole system is delivering justice in a cause. So far as this backlog or pendency, etc., they are of concern, and regularly efforts are being made to deal with them. Their machines, to the extent they help us, in sifting through volumes of data, etc., and channelizing the things proper, as has been rightly indicated. They are of immense help, and we are indeed using them, and we are going to use them more. But then, helping the machine to articulate a conclusion, or using a machine to help us in, or rather leading us to a conclusion, well, there has to be a difference. There is a difference that is always made. The other day we had been discussing the idea about sentencing policy in India in criminal justice delivery system. I was discussing with Dr. Vajpayee. It was nice of him. He gave his expert advice also, and we are working on that. Well, all said and done, we know that in that criminal justice delivery system, in the end of the day, after conviction, the learned judge would be looking at all those aggravating and mitigating factors before deciding on the appropriate sentence. And there, that particular decision making will be a human decision making only, because that has to take into account a variety of factors, ponderables, imponderables, the surrounding factors. Friends, I have an impulse to share with you that in our Indian philosophy, particularly aesthetics, we have those concepts called navras. These are those 9 human emotions or sentiments, starting from love, then that is the first one, and it's laughter, sorrow, anger, energy, fear, disgust, wonder, and finally peace. Now these are human sentiments, and they are integral part of a decision making when we are dealing with human beings. And these are the factors where a human brain who is capable of empathy is at work. So we take the help from machine for sifting across the things, putting the things in order, but then at the end of the day, the final decision making definitely remains with the adjudicators, and there we ensure, we all as the law professionals, what is required for us to ensure is that since we all are dedicated to the constitutional morality, this black box system, whatever we use, that remains a glass box for all of us, transparent altogether. Thank you so very much.
Thank you. Thank you so much, sir. And as we conclude with this session today, there are 3 important reflections which stand out very, very clearly. The first reflection is that technology is no longer at the periphery of judicial system. It's already becoming a part of the main architecture of this entire judicial ecosystem. And all kinds of initiatives which Supreme Court has already taken, they very well demonstrate that we are on the way towards institutional reforms for adopting and adapting to this technology. The second important reflection here is that no matter what, every development, every technological advancement, every framework which we create should be constitutionally anchored and human-centric in its approach, because it's we human beings who are at the end of it. And the third very important reflection which emerges today is that the future lies not in replacing human beings, which is the extension of the previous one, not in replacing the judicial system, but in strengthening the entire system when it comes to equipping courts and judges with tools, technologies that enhance research, streamline case management and reduce pendency, and of course expand access to justice. So with this, the roadmap ahead, which is a very important key takeaway from this important panel discussion. The roadmap ahead requires clear ethical guardrails, it requires transparent implementation, it requires institutional oversight, capacity building within the judiciary, and finally, and very important one, continuous public trust. So with that, we conclude the session. Thank you very much, everyone. On behalf of National Law University, Delhi, I extend my sincere gratitude to all the panelists here, Justice Maheshwari ji, Shardul sir, Vikas, Arya, Rajneesh ji, to each one of you for taking out time to join us for this panel discussion. I also extend my sincere gratitude to my team, to India AI Impact team, Dr. Sonu Gupta and her team, for giving us this important platform for this deliberation today, and to, of course, all of you, each one of you, all the participants, for your thoughtful attention and engagement today. So with this, I would request my colleague Dr. Dakshina Chandra to present a token of gratitude to the panelists here. This is the memento from MIT as well as National Law University, Delhi. To Shardul sir.
No, we can, there are some more.